welcome to In Vivo, a live event from the San Antonio Express News. I'm Nancy Martinez Prayer Johnson, Deputy Metro Editor. Can a child be prosecuted for his alleged plot to attack his school? Will a parent who is accused of purchasing tactical gear and ammunition for that child be convicted? Those are the questions we'll consider about the first case of its kind in Bexar County and possibly the United States. We're joined by someone uniquely qualified to help us understand the legal and constitutional stakes, John T. Hunter, a veteran San Antonio criminal defense attorney. So he's led local and state defense attorney associations, and you may recognize him from a high-profile murder court cases, or several, involving Texas rapper Tay K, Air Force Major Andre McDonald, and Mark Howerton. A big part of my job here at the Express News is to lead the crime and courts team. So I have read his name. I have double-checked direct quotes from him in different cases, but this is the first time I get to meet you in person, John. Welcome.
Thank you for having me.
Thank you for making time for us. I know you have a busy schedule as well. So let's continue with a brief overview of your experience in some of those cases. I know we could be here all day long and you could talk about these cases specifically, and everybody is, of course, very interested in them. But could you share more about those cases and what their outcomes were?
Sure. Let's see. Mark Howerton was a gentleman I represented through two trials. He was accused of murdering his girlfriend, Kaylee Mandotti, who was a cheerleader at Trinity University. There were lots of aspects of that case and the conclusions that were reached by the medical examiner that I found troubling. There didn't seem to be proper regard for the circumstances in which she arrived at the hospital and was treated and the traumatic nature of that. There wasn't enough consideration of the fact that they had engaged in extensive drug abuse. And so we tried the case in 2019, I think, and it ended in a hung jury. We had a lengthy appellate process in the middle of that, trying to prevent it from being retried for several constitutional issues. At the end of that process, we were forced to retry it again. The jury acquitted him of murder, but he was found guilty of aggravated assault. And that matters on appeal. I don't represent him on appeal. But that it's still pending and trickling through the courts. Andre McDonald was a major in the United States Air Force, accused of murdering his wife, Andreen McDonald. I tried that case with a dear friend and colleague and hero of mine, John Convery, and then with assistance from some other great lawyers, Jonathan Chavez and Zoe Russell. And we tried that case. He was acquitted of murder, but found guilty of the lesser offense of manslaughter. That matter is similarly on appeal. I am representing him on that appeal. And then Tamor McIntyre, whose rapper nom de plume is Tay K, it was just tried a few weeks ago in the 187th for a capital murder case. He was acquitted of capital murder, but found guilty of murder. He was sentenced to 80 years, which, I mean, on its face looks kind of rough, but at the end of the day, I think that we can say that it's a victory for Mr. McIntyre because he was already serving a lengthy sentence in Fort Worth. And the way that Texas parole law operates, it functionally only added maybe a couple more years onto his parole eligibility date from what he was already having to face. So pleased with that. That matter is also on appeal.
Yes.
So,
and are you going to represent him in the appeal?
Planning to, yes.
Okay.
It's still kind of early days in that process.
Okay. Super interesting. Are you, as I listen to you, and obviously you have a great record, and you are really making a difference in the lives of your clients. Why defense attorney? Why did you choose this side?
Probably maladjustment. Maladjustment probably is the best answer. I have a strong anti-authoritarian streak, and I'm not like a no government anarchist, but I do feel like it's really important, no matter what the issue, that the government's being put to task and accounting for what it's doing and justifying that by a really high burden, whether that's putting somebody in prison, whether that's taxing you, whether that's regulating you. I want to insist on that not being something we just accept because the government tells us to. And so this is a way to do that and earn a living and, not go to prison.
Yeah. So this is and this is definitely relevant to this case we're going to talk about today. A few quick notes before we begin. John is not directly in the defense of Ashley Pardo or her son. So he's not working. You're not working on the case.
Correct.
And you won't be working for them.
No.
So he's not connected. And then he's here to provide outside legal analysis from his expert background. And you heard a little bit about his expert background there. Most importantly, we want this event to be interactive. So don't be shy. At the bottom of your Zoom, at your window right there, you will click on Q&A button, and then you send us your questions there. So it's not in the chat, it's in the Q&A button. So please, again, don't be shy. Send us your questions and we want to hear from you. We really want this to be a conversation. So let's start with an overview of the case at the heart of today's conversation. Usually I just go free and just talk, and I can talk forever probably, and that's what my husband says. But I do have some notes to kind of keep us on track, so just kind of forgive me as I'm looking at those. And there's a lot of background, and I want to make sure that we get it right. So on May 12th, Ashley Pardo and her 13-year-old son, they were arrested after San Antonio Police ISD officials, San Antonio Police and San Antonio ISD officials said the boy was plotting a mass shooting at Rhodes Middle School, and that's on the west side. So allegedly, he had a fascination with past mass shooters, and he drew detailed maps. Now, this is what police said. On the day he was arrested, he showed up to school wearing a mask, and that's the school. If you're watching live here, on the day he was arrested, he showed up to school wearing a mask. He was wearing tactical gear. Officials hadn't said if he was armed, though. So that is something we obviously asked. There was a news conference. We've had many conversations and emails back and forth with officials, but they have not been able to say or tell us or decide to tell us if he was armed or not. But that day, the alleged plan of attack was thwarted by police. So they foiled it, they stopped it, or that's what they said, right? His grandmother had already called police, though, to tell them that her grandson had left a handwritten note on the kitchen table. So on that note, he listed the names of several mass shooters, and next to their names was the number of people that each person had killed. Again, this is according to the affidavit and to police. The grandmother also told police the boy told her that he had access to guns and ammunition that he said his mother paid for, and he told his grandmother that it was in exchange for babysitting his siblings. So that is Ashley Pardo's mugshot. I actually like an edgy haircut, so I actually admire her hair.
It's a good color.
Yeah, it's a good color. It works. So that is her. No one was harmed. This is super important for us to think about here as we are covering this case, if we are talking about it, is that no one was harmed. So Pardo and her son do face terrorism-related charges, and that's what we're talking about today. And it's based on a new Texas law. We don't have many other details about the boy's case because he's going through the juvenile court system, and they are very, very tight-lipped with that information. They will not give us much information at all. Authorities have charged Ashley Pardo with aiding his plan by buying that ammunition and tactical gear. The arrest affidavit says she knew about her son's threats against Rhodes Middle School and that she was in constant contact with law enforcement, child protective services, and school personnel, but she refused to take their concerns seriously. So that is something that's said in the affidavit, and that's something that Chief William McManus of the San Antonio Police Department has said. John, when you look at the arrest affidavit and just this case in general, what stands out to you?
Well, the things about the specific case that strike me as interesting from reading the affidavit would be, first, as you pointed out, there's no discussion about an actual gun. And it doesn't seem limited just to the boy not having a gun, but I didn't see anything in there talking about whether or not she actually owns firearms. So There's discussion about her acquiring bullets for him and magazines. And so these are the accoutrements that you would put in a gun. But it seems to me like that's an odd detail to leave out because that's the real kicker. And then in terms of the other, material assistance that they're claiming she provided, they're talking about a vest that is capable of having body armor plating in it, but there's no body armor plating discussed in the affidavit. So at
Oh,
that
see,
point,
I didn't catch that.
it just seems, there's a helmet and some clothes. So it seems to me like what we're talking about here is um, a costume and live ammunition. And that's a pretty small amount of evidence, I think, for this indication. Obviously, the notes, the rhetoric in the notes, the reference to these other mass shootings is extremely troubling. You'd have to be just living on Mars to not recognize how troubling all that is. But um, we're discussing in her case the question of whether or not that's a material assistance in the promotion of some kind of a plan or a conspiracy to commit a specified criminal act like murder, arson, um, human trafficking, those kinds of really, really serious offenses, uh, with an added specific intent that that be done to sort of, invoke mass fear or to undermine the operation of government or something like that. The idea that all of those kinds of claims could be built on a costume and bullets seems a little tenuous to me.
There's some more details in there. They did say that he told the grandma that there were guns at the house. But again, yes, they didn't point that out. They didn't say this is what we found. But that's usually the case with the media. We ask for information, we ask for a lot of information, we get very little. And then we try to get as much as we can. But as you can imagine, the investigation is ongoing, it's intense, and they have to retain some of that, right?
Sure. Yeah. What
Um,
all I can do is basically scrutinize that document.
yeah,
It's the affidavit for arrest. And
right.
the goal of that document is the officer is swearing under oath to the facts that he believes would give probable cause to believe that she should be arrested, that we can confine her and take away some liberty and charge her.
Mhm.
Um, based on the information contained within the four corners of that piece of paper. And so in a world where there isn't this new terrorism statute or it's accompanying statute for helping or assisting the person, and you go to a magistrate saying that she bought him a costume, there are bullets,
Mhm.
grandmother says there might be guns. It would be very hard, I think, for a magistrate to say that that's probable cause of anything.
Hmm.
It might be suspicion. It might be a reasonable enough basis to temporarily stop them and say, "Can you explain yourself? I'm a little worried about this." But um, whether or not it would meet the threshold for arrest could only be satisfied based on this new law, um, and that calls into question the law itself.
Interesting. So a little background on that law. I did, some research on it. It's brand new. And in fact, we did not know that this was the law being used, or I didn't even notice when I read that affidavit at first. It was breaking news. We went through it quickly, tried to get it up. We have a healthy competition with TV stations, try to get first. And so as I was looking back at it, I was thinking like, I wonder what that is, but I didn't go back and make time to research it at the time. When San Antonio Police Chief Willie McManus had a news conference, he pointed out that it's the first time of using this law. So this law was the new terrorism law, and it was in 2023, which was more than a year after the Uvalde school shooting. That, of course, we all know that tragedy. That massacre left 19 students and 2 children dead. Um, it was a young shooter, and I won't name his name here, but we all know the story probably too well. And 2023, it ended up being more than a year after that shooting, Republican State Senator Phil King introduced Senate Bill 1518, and that created a new offense. So that was aiding. And now, Graham, if I get some of this wrong, please correct me. Don't be shy. So that created a new offense, which is aiding in the commission of terrorism. It was passed and went into effect in September. And now, under Texas Penal Code 76.03, it is a felony to intentionally raise, solicit, collect, or provide material support or resources with the intent or knowledge that they will be used, at least in part, to aid in the commission of a terrorism offense. And I'm reading that slow because it's a lot.
Sure.
And we are not used to the legalese, right? So when you hear that charge, what are your thoughts on that?
There's a lot to unpackage. So, first of all, the statute that the mother in this case is charged with is sort of tied into the preceding section of the code, 76.02, I think, which is the terrorism crime.
Mm-hmm.
So to understand that, that in and of itself is a weird one. It creates a crime if someone commits or conspires to commit, and then there's what I call a laundry list of different offenses. Murder, aggravated sexual assault, kidnapping, unlawful restraint, arson. I think sex trafficking's on there. A couple others that are a little bit less obvious, but it's like 11 different pre-existing criminal offenses. All have been on the books for a very long time. Some of them have been on the books forever.
On their own, not under terrorism.
Right. I mean, it's always been a crime to commit murder. It's always been a crime to commit aggravated assault.
I think most people, when they think about terrorism, don't think that, I mean, I don't know, this is what I think about, but September 11th.
Yeah, that's my
So,
that's my idea of terrorism.
yeah.
I mean, what is terrorism? Yeah, I mean, terrorism is more of a political term. It can be at times a propagandist term. It can be a philosophical term related to violence that is motivated by some kind of out of the ordinary reason that isn't directly connected to the conventional reasons that those crimes are committed, right? I mean, it's not just anger at a person. Most murder is committed by someone angry at someone else for a specific reason, right or wrong, whatever. But it's a
passionate, different, yeah.
Yeah, it's a one-on-one conflict.
Yeah.
But an act of terrorism would be typically done for a political purpose,
Okay.
or some sort of secondary motivation. So the killing the person is just a means to an end of whatever their actual agenda or objective is. But that's not really a concept that the law has ever had a need to fixate on, because killing people is against the law, absent justification or excuse or something like that the law recognizes. So there's no need to, pile on with something else and create these additional definitions. That's what the law does. And I mean, I can get into what I think is going on here because it seems to be part of a broader spectrum. I mean, the bill that Senator King introduced comes with several different components. It has these issues related to terrorism itself. So it's now the specific intent to have this sort of political or mass terror, mass fear motivation while committing an offense with its own criminal intent. That's what the boy is accused of doing. The mother is accused of this idea of essentially aiding and abetting, for lack of a better word, giving assistance of some kind. And the definition of assistance is extremely vague. But then it also, in a different section of the code entirely, I think in like chapter 65 maybe, creates a registry of people who have been convicted of terrorism offenses under chapter 76. So when you think of a registry, most people have at least heard of the concept of a sex offender, a registered sex offender.
Yes,
right?
yes.
We have a database that's kept by the Texas Department of Public Safety and that is coordinated in turn with a federal database of everyone who's been convicted of a sexually related crime. And they are required to register, saying, I live at this address, I work at this place. They're not allowed to be in certain locations where children might congregate. In some places, cities have created secondary obligations, like they have to put up signs saying I'm a registered sex offender if they're, if it's Halloween or, something like that. It's public shaming of the person. It's basically like the 21st century equivalent of let's put them in the stocks out in the courtyard in front of the church or the courthouse, and everyone throws tomatoes at them.
That's giving Handmaid's Tale right now. Sorry.
Yeah.
Yes.
So that's sort of the idea behind that. And I mean,
And also like is it similar to the do not fly list too? Something like that?
well, kind of. Do not fly lists are a little bit more nebulous and on shakier ground,
Okay.
maybe than this. I mean, there's a complex statutory framework supporting this, and there's been a lot of litigation about its propriety. And I mean, I don't think that those things are constitutional, but pretty much every court in the country disagrees with me on that.
Yeah.
This is trying to create that same kind of a model
Yeah.
for a specific category of violent offenses. And I think it's interesting that it's come at the time that it has. I mean, since the pandemic, Governor Abbott and the Texas legislature have been on a major crusade about issues like immigration.
Right.
And I mean, we've seen Operation Lone Star run amok in South Texas. I mean, a huge officer presence, military dispatch to the border. We have a national scene of controversy about that same subject overlapping it. And one of the recurring narratives of the folks that really are arguing the heaviest for strict immigration and, over the top enforcement of those things, frequently reference cartel violence and the drug trafficking situation with the cartel as being essentially a narco-terroristic operation that's occurring at the southern border.
Yes, they call them terrorists. That's right.
And so I think that that's what this bill was actually designed to do, is to, create this tie-in to the rhetoric about terrorism, right? It's a political concept. We want to dehumanize the issue of immigration by making everyone out to be a terrorist. There's big talk now in the media about these people from Venezuela and whether the Alien Enemies Act should be applied to their deportation process, whether they're entitled to habeas corpus. I think it's all part and parcel of that same issue. And it's really interesting because I dug into the legislative history a bit after you contacted me. And there's some committee notes from the House debate so that the bill could be, passing both houses. It was a very odd set of questions, and it doesn't have full context, but for some reason, the representatives voted that section of the floor debate be included in the minutes. And the question was put to Representative Guillen about people living in multifamily households, and especially Latino people living in multifamily households in South Texas. And it's not uncommon that someone in that multifamily household might have marijuana on them, things like that. Would that put everyone in the household at risk of being on the terrorism registry? And Representative Guillen assured that no, it would only apply to convicted people. And that's the end of the minutes. I thought that's an awfully weird question for a terrorism bill.
Even for marijuana?
Well, that's the question. So let me tie it all together because I don't want to run too far afield.
Yeah.
The mother is charged with providing this assistance to the terrorist, quote unquote, right? The person who's actually trying to commit this offense. And
again, you're talking about Ashley Pardo now.
Right. This is Ashley's charge. And the question is going to be, what is material assistance? Is buying your son a box of ammunition material assistance? Is buying them a vest material assistance? Well, I mean, if you'll recall from especially right after 9/11, I remember this vividly. The Bush administration went to great length to try and tell people that if you bought marijuana from a drug dealer, you are financing terrorism. It was this really over the top, ridiculous kind of a claim. But it seems to me like that might have been what that conversation on the floor was about, is you could use this as a backdoor to make virtually any kind of criminal behavior that has a connection or an association in public consciousness with organized criminal activity as a tie-in to you're providing material assistance to terrorism. And that kind of strikes me as what the bill might be have envisioned to be by those who put it on the floor. by the kind of agenda that folks like Senator King seem to be pushing.
I think you're absolutely correct. When I did some research, I did find that, like on the first reading, for example, of the bill, terrorism and immigration is all they talked about. They'd never talked about school shootings. And then also, after the Uvalde school shooting, a lot of Republicans didn't come out. I know at the time I was in the editorial board, but we pointed that out often and just said, well, hello, what are the Republicans doing or saying about this? Like, what are they doing to try to prevent this? So it did strike me as odd that they would have this terrorism related bill just for the school shootings, right? And of course, we all think that's why I included the Uvalde reference earlier. Like, we think, oh, this was made for this, but I believe you're absolutely right. When you go back and you look at when it first started and all the conversations they had as they were trying to pass that bill, they were talking about immigration.
Yeah.
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 And the
I think
boogeyman, right?
I think that, yeah, it's a different set of boogeymen. And so what this, I think, opens up is this is the law of unintended consequences, potentially, right? I mean, whether you agree or disagree with what the legislature is trying to do,
Mhm.
I personally do not agree with any of what the legislature has been doing the last two sessions, but that's just me. The point is that whether the intentions are good or bad, you can't just judge a law by the specific intentions that you bring to the floor when you vote on it. You have to understand that language, especially if it's not well drafted, and this is not a well drafted bill, open up its use and abuse for all sorts of permutations, all sorts of different possible things. Um, and now what we have is a situation that's probably not what the drafters intended it to be, but it's available potentially because that language is very broad. And now it's being applied to this. And so the separate debate is, well, okay, we have this law, whatever it was meant to do is one set of issues entirely. But we all want to live in a world where we can take our children to school and there's no danger that they'll be killed.
Absolutely.
And I'm very respectful of efforts made towards that objective.
And you're a father. You have two young
Yeah,
children.
yeah. I mean, it's something that you think about all the time. But we have to balance that against the fact that we live in a world where we don't want to prosecute thought crime. We don't want to prosecute people solely for what they write or think. And we have to draw a line somewhere. And the law has historically drawn that line at just the basic idea of we have a series of things in Texas law and throughout the United States called inchoate offenses. These are incomplete crimes. You don't have to actually kill someone or actually walk away with the money from the bank robbery to be charged with those criminal offenses. Attempts at doing so or conspiracies with other people to do so can be enough to bring a criminal charge. Solicitations to do so. Asking someone, I'll pay you money if you'll kill so-and-so for me. That communication can be enough to bring a criminal charge. So we have those sorts of ideas. And I mean, in good faith, trying to pay someone to commit a murder for you is not protected speech. You don't have a First Amendment right to do that. But we have to be careful that we're not prosecuting people for protected speech that might just look like a criminal solicitation or a criminal agreement. Things can be said that they don't actually mean. Things could be said in jest, but the other person doesn't get the joke. And so we're always trying to be sure that we're actually punishing a real, bona fide, guilty mind, someone who is actually thinking these things because that's what they want. And police and prosecutors get frustrated because we can't read people's minds. And jurors sometimes think to themselves, well, I don't know what the guy was thinking. How do they know what the guy was thinking? You're asking me to convict. No one died. Like, why should I convict this person? And so they're always trying to crawl back that line in the sand moment about when it becomes criminal behavior. And that's what this law tries to do. And some people may say, well, good, we don't want mass shootings, so anything along those lines should be promoted. But the danger is at some point you're going to get into thought crime. And that's what worries me.
And copycats, I guess, would copycats be under there? I mean, I know the level of threats to schools has like just gone up tremendously. And I feel, and I'm a former teacher. I left journalism for a while and I went and I was a teacher at a junior high for about 8 years at different school districts. And students, they're going through some stuff. It's hard. It's hard to be a kid. I'm so glad I'm not growing up at this point. In our time here and these social media and all the pressures they have. They want attention. They have some really deep mental health issues. Ashley Pardo's son, it was noted in the affidavit that he was suspended from his school. They sent him to an alternative school, and that he had tried to kill himself. I mean, that's in the affidavit.
In a very troubling way.
It's like over 100 stitches,
yeah,
right?
it didn't strike me as a cry for help. Looked like a bona fide attempt to kill yourself.
Yeah.
And
100, yeah.
it's obviously there's some serious mental health concern that needs to be thought about there. I mean, it just that's heartbreaking.
Right. So I'm sure probably his defense, if it gets to that, right? Would you think that his defense will like really emphasize that?
I would hope so. Yeah. I mean, because I mean, this is an ongoing question, right? And it's been in the media and debated a lot since the George Floyd death about should criminal justice be so focused on, enforcement of the law, carceral punishment, like bringing people to account, or are there certain aspects of this where, harm mitigation or trying to provide, resources to people who are obviously troubled might be appropriate. And I think maybe because people were so angry, that it gave the opposing side of the debate a lot of ammunition to say, well, we can't just get rid of police officers, right? Like, what do you want us to, what you just think we could arm the city with social workers and all our problems would be fixed?
Right.
So there has to be some middle ground here. But this one kind of just jumps out as being, well, this kind of looks like we could find a middle ground. If the child is that suicidal, then this is a mental health crisis. This is a medical intervention problem. But I mean, we're Monday morning quarterbacking.
Right.
I mean, I don't want this to sound like a complete criticism of the police. I mean, I'm not pleased with that affidavit. But I mean, it is what it is. I would not want to be in Chief McManus's shoes or the detective who is involved in this case, where you look at it with that much more jaundiced eye and say, okay, this child needs help. I'm not going to treat this as a bona fide mass shooting case. And then the next morning you wake up and the headline is there was a mass shooting. That would be a terrible place to be.
Right.
And so the motivation here is obviously a pure, good, civically minded motivation that we want police to have. Wouldn't criticize that. But I mean, there are other things that can be done. I mean, you can have involuntary commitments, especially with minor children. That's a little bit easier to do than it would be for adults. There are interventions that don't require the full weight of criminal prosecution to be brought upon you for it. I mean, maybe those were explored and maybe they weren't. I mean, I can't say, but those would be the things that I would want to know more about. Certainly, like what were those options explored? Were they considered? Why weren't they? Is this a resources problem? Is this a money problem? Those kinds of questions.
To try to get the boy help, counseling or whatnot.
Right.
It sounds like part of it, though, is that the mom was in denial. I mean, that's according to the affidavit, that she just didn't see a problem with it. But you never know. Maybe she was saying that in the heat of the moment, or she was anxious or having her own mental health issues. There's been a lot of coverage about her as well, and some of her tattoos and lifestyle choices.
It's very hard to say. I mean, I think about, I grew up in the Texas Panhandle. I grew up in Amarillo, Texas, which is, cowboy country, gun country, God-fearing, Marlboro Red smoking America.
Second Amendment.
And there was a young man that I knew who stole some gunpowder out of his father's reloading system in his garage for reloading shotgun shells and put it in a Coke bottle and threw a match in and boom, and not blew out windows, burned his legs. It was this terrible thing.
Wow.
And I remember it being, everyone reacted just in shock and horror, and authorities were involved and child protective services are involved, and it's like, these are some of the most wholesome, sweet people in the whole world. This child's not a troubled soul. He's an idiot, and he's just
His
doing.
frontal lobe wasn't developed yet. Yes.
And in that culture, there's just a lot more tolerance for the
Yeah.
fact that, like, okay, kids do stupid things and they blow stuff up sometimes.
Yeah.
And like, it just would never have risen to the level of assuming that because you're flippant with a governmental authority's concerns about whether your child is troubled, that you are an irresponsible or bad parent. Right?
Yeah.
Those don't necessarily meet up. So it's hard to say. We can judge her for not being concerned.
Yeah.
But I mean, she's the parent.
Yeah.
That's a whole different social question. Is at what point do we just say, okay, we can't trust you to be a parent anymore? Where's that line? And I mean, that's probably not a conversation for a criminal defense attorney.
No, it's a very difficult question there. We are getting some questions in, and I don't want to get behind on them. So let me kind of look. Let me see. Someone has said, this is an anonymous attendee, so thank you. It says, there have been foiled mass violence plots in San Antonio before. What made this case different? So I know, the new law probably, but do you want to say anything else on that one?
Yeah, I think that the new law is definitely what we'd have to point to specifically. I mean, it changes the landscape. It's a different tool for police, and
Yeah.
Whether that's appropriate or not is the question.
Right. And are you aware of other mass violence plots before, and how did that work out?
I've never defended anyone on a mass violence plot.
Uh-huh.
I know some lawyers that were loosely connected with the El Paso mass shooting case, and I followed that with interest because of the question about capital punishment, and the fact that it's a dual prosecution, federal and state involvement on the same conduct, things like that. I mean, the bottom line is most of these people are suicidal, and so they get what they want when they commit these acts. So there aren't as many examples of it as there might be.
Yeah.
I'm trying to think. El Paso, the person survived and was prosecuted. I think the Aurora shooting that happened. I can't remember if the Parkland shooter was prosecuted or not, or if he was killed on the scene. But
I think he was at the scene, I think. But
I mean,
unfortunately, they kind of run together because there's so many now.
Yes, and it's really sad that we can list them off like that.
Yeah. We had a question early on, and I'm going to read this one. It's kind of just a back to basics kind of question. It's from Jose Picon, and he says, can you please explain how bail bonds work? It seems Ashley Pardo made bail almost immediately after she was put in jail.
Sure. So bail is a constitutional right in a criminal case. The concerns of the government are that you're accused of something that, if you're found guilty of it, you could go to prison for. And it may be that what you're accused of is dangerous to the community or to yourself or something like that. So those concerns are on one side, balanced against the fact that everyone in the United States is presumed innocent unless the government can marshal evidence and convince 12 people that you're guilty beyond a reasonable doubt, which is a timely and complicated process that you can't just do overnight. So in order,
Constitutional right, like
fundamental. I mean, fundamental to our whole system is that idea. And to ensure that that gets satisfied, the idea is that you should be able to assist in your own defense. You should be able to meet with your lawyer and talk about what your arguments are going to be, help your lawyer find evidence that might exonerate you, prove you're not guilty. You can't do that as effectively from a jail cell. And so the right to bail has these balancing problems, but it's always been said that laws about restricting people from getting out are administrative rather than punitive in nature. In other words, we're not holding you because you're guilty and we're punishing you. We're holding you because we don't have any other choice. Okay. So confinement is the last resort, and release is the default. We want people out helping their lawyer and being free. And the compromise to that is bail. Texas is a cash bail system. So the idea is that we ask you to put up money in exchange for your promise that you'll appear in court and that you won't commit any new crimes or do anything that would violate our expectations of an ordinary citizen. And if you do violate the terms of your bond, or if you flee to Mexico or something, then we'll forfeit the money. So, I mean, people get out on bond quickly if they can post the bond. A bail bond, as you normally think, is a third party who says, I will post the bond for you. You may not have, 20,000 or 100,000 or whatever the bond amount is, liquid cash to go and pay into the registry of the court. If you do, you put the money up, and win, lose, or draw, you get the money back. But most people don't have that kind of cash on hand. And so they contract with a bail bonding company who says, well, we'll put up the cash if you pay us a percentage of that cash as our fee, basically, and we'll assume the risk for you. And so that's how it works. And I mean, I think that people get upset when people accused of something heinous bond out quickly. But I think that's just because I think everyone would like to see the justice system move faster than it does. And so it looks.
Is it the part about watching the stuff on TV, on the series, on Netflix, on all these shows, right?
Sure.
That you just think, and the way that you follow it is basically, oh, it's done in a day.
Yeah, exactly. You get complete resolution.
Right?
Yeah, that's right. 30 minutes and the whole thing is done from start to finish. Yeah, I think that does create that expectation. I certainly came into law school with that kind of a mindset. And I had to be brutally disabused of that notion. Like some of my cases have taken years.
Yeah.
I mean, whole eras of my life have been going on in the background while this case has been unfolding, and it's frustrating for everybody. I mean, it isn't great for any side when that happens.
Right.
But it's the way it is, and there are a lot of reasons why.
I mean, as people are waiting, even if they're out on bond, they posted their bill, they're out. I mean, they still, in a lot of cases, have lost their job, and they're trying to find that money, and so it's still really disruptive in their lives as well, and they're living. How can they?
It's no picnic for sure. I mean, the reputational harm of being accused alone is massive, and sometimes, no matter what happens with the outcome, that reputation can't be repaired.
Yeah.
So, I mean, it's a tough deal.
Someone asked, another anonymous attendee, is it possible this trial could be removed from Bexar County because it happened here? And then I'll add a little caveat to that, which you just mentioned, is like maybe the media coverage as well. So what are your thoughts on that?
Like as a change of venue, I guess, is sort of the sense of it. Yeah, I mean, the main reason that something like that would be moved is because the media saturation gets to a certain point where it would be believed by everyone that you can't get a fair trial in the county. Yeah. But I mean, we're in a different world, and I'm very skeptical about how probable that is, because I mean, in the internet era, if there is media attention, then the media attention reaches everyone at the same speed. We could move this case to Alaska, and there'd be people that would be able to find all sorts of information about it.
Right.
So, and the Supreme Court seems to have expressed that cynicism. The Enron case, for example, Skilling, that went to the Supreme Court on that very question about whether the media saturation was so much, and the court was like, no, it's got to be something more than just that.
Okay. And this is a question of mine. If you can talk more about that, what I'm getting from you is basically it's a slippery slope with this, just to kind of simplify it. But what other constitutional risks do you see? Like, could this be something that would enhance penalties or sidestep the due process with that proper jury oversight? What are your thoughts on that?
Well, yes. I mean, there's a case called In Re Winship that says every person accused of a crime has to have their guilt proven beyond a reasonable doubt as to each element of the criminal offense. And laws like this are odd because on their face, you look at it and go, oh, well, there are more protections, because it's not enough to just prove that they conspired or like agreed to help someone commit a murder. They had to have done it with an extra specific intent, which is that it's, in the promotion of terrorism, that it's to disrupt a governmental operation or cause mass fear. But because that's such a impossible thing. We can't, like I said, we can't read people's minds unless they write a manifesto saying, I'm doing this because of, I support Al Qaeda or whatever. I think that it's not really an element in the true sense. It's more of a mission statement or a propaganda tool of the prosecution to say, well, you should really convict this guy because it's not just a murder. He's an extra bad guy with an asterisk on it. Um, and, and and part of that is because the element is so easy to satisfy. We talked about that list of different phrases about how it can be material assistance, right?
Mhm.
Aid, promote, assist, you know, uh, support, knowing at least in part that it could be
Yeah, that caveat, at least in part.
right.
Yeah.
So the marijuana example I was giving about Representative Guillen's floor debate. I mean, let's say that we have a group of people who sell marijuana in San Antonio,
Mhm.
and they're nonviolent. They not big time players, but they move marijuana product through the city. One of them goes out and gets in with the cartel people and decides to go off and do that, but he still is owed money from his local, dime bag street dealer stuff. Murders committed by that member of this conspiracy as a product and result of his dealings with these other people that are cartel people. And now we have all of his buddies rounded up and scared within an inch of their life to cooperate in the case and so forth. They could potentially threaten them by saying, look, you gave him his representative share of your little criminal enterprise to sell small amounts of weed. That's, at least in part, material assistance, promoting an individual who committed a murder that we maintain was done with this added intentional element of disrupting government operation or causing mass fear. So now you're charged with 7603, not just, distribution of marijuana. That's an extreme example. But the reason I give it is because it's that kind of vagueness in this way that the statute is worded that makes it not really a protection that that's an added element. It makes it a detriment to the defendant because anything could be that kind of material assistance.
And again, he didn't pull the trigger.
Wasn't there, had no affiliation with it, right? It's just, I mean, he had to buy the bullet somehow. He happens to be involved in this other criminal enterprise unrelated to what he's doing with these bad actors.
Mm-hmm.
It gets all tied in that way.
Yeah.
And it makes it hard. I mean, one of the concepts that constitutional law talks about is that a law should be written with enough specificity that a person of ordinary and common intelligence can understand what is prohibited.
Mm-hmm.
The example from antiquity was, I think it was Caligula. He got a kick out of writing the laws on bronze tablets in extremely small font and putting them up really high in the forum, and then executing people who violated them, even though no one could read what the law was, but it was technically posted, it was technically published.
That's super interesting.
I mean, and so that concept has carried forward from antiquity, and we call that procedural due process. And I mean, I guess it's substantive due process too, in the sense that, like, a vague law should not be allowed to function. So anyone who is accused of this should be exploring the possibility of challenging the law on vagueness and overbreadth and saying, like, I can't figure out exactly what I'm doing. And we have these problems in other laws. I mean, I was talking to you about the federal sex trafficking statute, which has very similar conceptual language.
I was just about to ask about that. Yeah.
Yeah. I mean, and the way I read that law is if a truck driver gives a hitchhiker a ride into town, and there are some clues that maybe that person is going to go work in the sex industry in San Antonio, there's an argument that that's federal sex trafficking, even though they're not involved in the business, they're not profiting from it, they're not going to have sex with the person, they're not taking them to a place where they could have sex, they're just giving them a ride down the road.
Trying to be a good Samaritan.
It could be arguably enough under the way that law is written to say, well, that's assistance. That promotes the activity in some way.
But wouldn't they have to prove that there was some kind of agreement for going further than just giving a ride?
You'd think. I mean, technically speaking, some of that concept is there, but in actual practice, it's not a very high threshold for them to have to establish. I think that the aim is, look, we know who the bad guys are. Don't confuse us with the facts. And we're tired of having to debate the really important questions about like how much of a guilty mind they have. So we're going to back off the threshold and try and say, well, we only have to prove this very, very small component of any assistance, if you have any suspicion, a hunch that it might be related to the criminal activity, then we've got you, and we don't have, and that waters down the burden of proof. Right? That at its core is what it's about.
Wow. Here's a question from Olin Sluter. I hope I'm pronouncing that correctly. Is there a parallel here with hate crime enhancements and their potential political abuse?
It could be, yeah. I mean, hey, by the way, hey, Olin. I know Olin is a musician at the Pigpen, a wonderful guy, dear friend of mine. Yes, it could be very similar to issues related to hate crime. I mean, hate crime is one of those similar concepts where what is a hate crime? Almost all violent crime is arguably a hate crime. So you're trying to add on to and pile on to the severity of the charge and water down the burden of proof based on this very subjective factor that it was motivated by something other than just anger. I mean, and there's been a lot of problems with those laws too, and a lot of constitutional challenges to them. But I mean, they're still on the books.
Mm-hmm. We got a question earlier. Sorry, I'm getting over some allergies here. When deciding whether to take on a case, now this is a personal question for you, how do you balance the weight and emotion of a potential trial and circumstances with your professional duty to defend? It's a heavy question.
Yeah. Well, I mean, it's there's a lot to unpackage there.
Yes.
It's a hard job because some of the people I've represented over the years, their conduct offends me, their worldview offends me. I don't like them, but everyone is entitled to these protections because if we don't give them for the people we don't like, and for the least of us, then no one's safe. It's got to be as aggressively enforced with the crappiest people alive as it is with ordinary folks. And so, I mean, I was always taught slippery slope thinking is a fallacy, but I do think that history will show that quite often there's an erosion of your freedom, an erosion of your protection, and an erosion of the dignity that you get treated with if we allow for bad things to be done to folks just because we don't like them, just because they're reprehensible potentially. So I have to try and put that out of my mind, and I have to, find some other way to look at it. And there's usually a way. I mean, there's usually a way to get there. It just takes a little internal convincing.
Yeah. I mean, I think the other side of the coin, and you've talked about this, is also, the motivation could be it's kind of like Child Protective Services. Like they don't want that next phone call to say like the person on your caseload, committed this terrible crime, right? That mom killed that baby, or that student did take a gun to school and, kill people, innocent kids there at school where you should be, where you should be safe. So you kind of have that with this too. But again, you look at the motivation of it and the slippery slope factor as well, the erosion of it. A question from anonymous attendee. Is it possible that terrorism charges will be difficult to prove to a jury? I feel like you've talked about it, but I'm really excited to be getting these questions.
Yeah, no, I mean, I think it will depend. I mean, if it's highlighted just exactly what it is that they're being tasked with deciding,
Yeah.
and how de minimis that really is, and how that could be applied to things that are in their wheelhouse and their daily life, and that, be careful what you wish for, then I think a jury would acquit him, no problem. No one was killed. We don't even know at the moment. I'm just going to assume there's no gun because I'm convinced if there was, they would have actually put it in the affidavit. I think a jury could acquit on that. But by the same token, um, if people are driven more by their emotional response to things like Uvalde, like the mass shooting and gun violence problems in the country generally, um, there will be a temptation to indulge in that end justifies the means thinking and say, well, fine, I'll convict him. Never mind that I think this law is vague and that it could be enforced inappropriately. I don't want this to happen on my watch.
And the same with the mother, with Ashley.
Sure.
Well,
sure. Well, I mean, because this is, I mean, parents are responsible for the torts of their. I mean, you can be sued as a parent if your kid goes out and gets drunk and drives your car and kills somebody.
yes.
And so I'm not saying that, I think it's important that parents understand that your conduct and the way that you conduct your household has the danger of exposing your child to something that will make both them and you liable. For a catastrophic event. I mean, that shouldn't have to be something where the law is the reason why you modify your behavior, but at least people need to know that.
Right.
And I'm not saying that reckless or negligent treatment of issues like gun safety in a home should never be a factor that we consider. I mean, parents in a mass shooting event need to be scrutinized and at least considered for maybe prosecution, at minimum civilly prosecuted. I mean, civilly pursued for damages.
Mm-hmm.
But this is about the bigger problem of, can we ever have a world where we can preempt crime? We can stop it before it happens. I mean, I think that's pie in the sky thinking, but.
Gun violence remains a significant concern, as you say. There's a Bexar County special survey that was just released, and we had a story on it yesterday about gun ownership. About half Bexar County residents who responded to the survey said, "Yeah, we own guns." Do they take classes? No. Do they think more people need to take classes? Yeah, maybe. Guns are just part of our lives as well, and they're around. There was a case over the weekend. I'm sure you saw that, about the 17-year-old boy who left, or he's allegedly left a loaded gun on his dresser, and his toddler brother got that gun and shot himself in the head.
Those happen all the time.
Yes. And so, you have these kind of dangers, and people, it just seems they're very flippant about guns. And also, part of it was really an interesting study, because, in the survey, people said, we do it for our protection. We have these guns for our protection. However, some of those same guns, and that's going to be part of the county's campaign. It's a PSA type campaign, and they have nonprofit organizations as well, that are helping with it. But, often those guns hurt them in their own homes too, or sometimes kids take them out, right? But is it possible, and I know this is more like a philosophical question as well, but would it be possible for lawmakers to balance that responsibility without legal overreach? Like, how could they be so specific in how they write a law? Like, maybe they can amend the law. Maybe this won't work out for them, and they'll go back and amend it. Like, what is your suggestion?
Well, I take the position that we don't need more legislating on these issues. Like, more laws is not the question, right?
Mm-hmm.
I mean, I live over sort of by St. Mary's Law School.
Mm-hmm.
Bandera Road, every night, all night, gunfire. I mean, just constant gunfire. And I've talked to law enforcement about like what's going on. Like, is there a gang war I need to know about? Like, and general consensus is most of these are juvenile people just popping off rounds into the air, having fun. And to me, that's such a simple problem that like it's inconceivable to me that we can't address something like that with the current laws that we have.
Yeah.
But what I think is that because we have so many laws, we tie up our resources in ways where they can't address real problems. I mean, we're about to do more of that. I mean, why we would go back to a full prohibitionist world for marijuana, to where we're enforcing these drug laws.
The THC is almost, that may pass soon.
Yeah, I mean, it's waiting on the governor's signature.
Yeah.
If the governor's watching, please don't sign it. But
yeah.
that like having to make police enforce those kinds of things, vice crimes, petty crimes, victimless crimes, um, making police do things that really should be the province of a social worker. Uh, I mean, we don't have an infinite number of policemen, and we wouldn't want an infinite number of policemen. So I would just like to start before we go back to session and say let's either change the law or create new laws. Let's have more serious conversations about enforcement priority. And I mean, we've tried some of those things, but we can't seem to get traction. I mean, the Joe Gonzalez, this district attorney's office had a great policy, wonderful policy about declination of all low-level marijuana cases. But before the science and before the legislative understanding about THC and hemp really got underway and was sort of understood, they can't really prosecute those cases under the current law. But the attorney general is going after him and causing problems and making it more difficult. And there's only so much you can do. Like that tension and that conflict is going to make it hard for people to effect a policy that will actually make those changes. But like that was very strong vision to say, like, okay, if we're going to make this a less violent city and a less dangerous city, I mean, a lot of that gunfire I don't think is violent. It's just reckless stupidity. We need to change our enforcement priorities. But how do you get that affected? Beyond my pay grade to say.
We could talk all day. We're getting close to the end of time, so we'll take this last question because I think it's a really good one. Gets to the heart of what we've been talking about. And so I know you've talked about the affidavit and that you feel it's very vague and doesn't have enough information, especially against the mother. And so this question comes from someone who says, if mom, Ashley Pardo, knew about the threats or potential threats and still purchased the ammo, would that fit this crime? I would add the caveat that, maybe in the investigation, the police would uncover that, right, and show some proof of that. Even here, when we're writing stories about it, we have to be very careful as we write the headlines because, we only have so much space for those headlines, right?
Sure.
And we're working on a short time clock and we're trying to on deadlines. And so sometimes we just say, it was a planned attack. The mom did not help him plan the attack. We don't know that. That hasn't been said.
Yeah. Nothing in the affidavit says that. Like, oh, actually, this exit's better or something. Yeah, no. I mean, I don't know if there's a threat. Like the thing is, if you have your private journal and you write the most hateful, awful, violent things in the world in that private journal, and it's just for you, then there's no threat. Nothing's been communicated to another. Threats can't be conditional, and threats have to be heard by the recipient, or it's not a threat. The fact that there's reporting sort of anonymously that a grandmother, a parent, somebody has seen this boy's writings and they're troubling is different than a communicated threat. And so I think that's an important feature to keep in mind here. If there was a threat, then we wouldn't actually need any of these laws because there's a law in the book that's called terroristic threat, which is, basically verbal assaultive conduct meant to put not just one individual in fear, but, to disrupt public operations and to put mass fear into the equation, which has been the way that these kinds of cases have been prosecuted in the past before this law came out. So that would be the way to handle that. But no, that's the problem. You have a troubled child. You have somebody who obviously has got a lot going on in their life, and the mother buys them something that could be weaponized, may not be weaponized. Is that a criminal act? Just thinking about it, common sense, I would say, no, it can't be. I mean, that may not be smart, maybe something we can be judgmental about or, wish that it hadn't happened or try to learn from the experience moving forward. But I don't think it's a criminal act. This is going to try and make it one. And, I think it will do so with a lot of constitutional difficulty along the way.
We've gotten some good questions from the community, and we've been trying to answer most of them. Just to start wrapping up here with you, and just so we can understand next steps in the case, Can you walk us through, and let's just focus on Ashley Pardo, since she's the adult and juvenile is a whole other
Yeah.
a whole other
And
thing.
not my wheelhouse. I really don't do much
Yes.
juvenile work.
And it's just so quiet, like we don't know so much that goes on there. We try to go to hearings and, but it's very shrouded and for good reason, they're minors.
Absolutely.
And so what are the next steps in this case? So, if you could draw like a little flow chart of what we can expect, could the DA maybe decide to drop the case, or can you go through and see
The
possibilities?
DA could drop the case. The DA could change the charge. It doesn't have to stick this way just because the police decided to charge it that way. The warrant was issued because of 7603, but that isn't binding on the DA. The DA is the top dog in terms of the charging decision. However, it will be categorized and coded in their intake process. It will eventually have to go to a grand jury, assuming that they decide it should be prosecuted in some way, and assuming that that decision is for a felony offense. If it's a misdemeanor, the prosecutor can charge them on their own signature. But if it's a felony, then they'll need to present evidence to the grand jury to persuade them that there's probable cause a crime was committed. They could vote to indict the case, to true bill the indictment, or they could vote to no bill it, and then it would be rejected. If the DA really wants it to go forward, in spite of that, they could present it to another grand jury. They can keep doing that as long as the crime is within the statute of limitations for the offense. And don't ask me what the statute is for this because I'm not sure. My guess is it would, on some of these things like murder, be no statute of limitations. Then if it's indicted, it would be assigned to a district court, and then there'd be a scheduling order put in place. There would be preliminary hearings on different issues. If a lawyer wanted to constitutionally challenge her prosecution, if it does go forward as a terrorism-related crime under Chapter 76, they could file a writ of habeas corpus to challenge that facially before it goes to trial. So that's one possible,
After. Okay.
No, so facial challenges, meaning the law is unconstitutional in all applications, are you can raise those by pretrial habeas corpus. And so that's a separate lawsuit, basically suing the cause number, basically saying it's an illegal confinement of my liberty. This is a law that shouldn't be on the books. The trial court could have a hearing on that. And then however the trial court rules, that can be appealed before the matter goes to trial. And the judge may be inclined to stay the proceedings while that happens. But that's not required. I mean, it can also be done after the fact.
Okay.
So then there'd be a trial, and then
Appeal.
we wait on the outcome. Yeah.
Wow.
Appeals.
This has been super fascinating. I have learned so much from you. I think so often, we hear from police, we hear from the DA, we hear from that side, lawyers, in the prosecution, but we don't talk often enough to defense attorneys and to hear that perspective. And just hearing your thought process and your experience has been so helpful in just kind of opening your mind to just all the different possibilities. I know I've learned a lot. I know our audience has joined, really learned a lot as well. The questions have been really good. And so I'd like to thank you for joining us. To our listeners, this story is not ending anytime soon. We are trying our best to cover all aspects of this story, about Ashley Pardo and her son, and other stories on this as well. I mean, we work really hard to write those stories as well and as accurately and as timely as we can. And there's a lot of challenges with that. It's hard to get details, especially when the investigation is ongoing. But we're working at it. So we hope that you'll join the next In Vivo episode, and also just stay informed on expressnews.com. Thank you for joining us.
Thanks for having me.